Okay, so thank you so much for having me here today to participate in such an exciting conference and on such a wonderful panel. In particular, Ms. Joella Rowland and her wonderful colleagues at the Journal. What extraordinary stewards of today's discourse. And additional thanks to our moderator, Professor Grimmelman. The type of person who, after a conversation, he makes me understand not only his opinion and his ideas better, but also my own understanding of my own ideas. And we'll see if I can manage this. Okay, so I also practice law like a bunch of the folks up here, and I worked on both First Amendment and antitrust matters. And they were each challenging in and of themselves, but one thing that wasn't challenging about them was trying to figure out which kind of matter it was. Is it First Amendment or is it antitrust? In point of fact, they didn't typically overlap that often. And what I'm looking at today is the instances in which they do overlap. When you have antitrust challenges to information product redesigns, and it prompts a defense of, I have a First Amendment right, I am immunized from antitrust. And what we're going to do is fast look at one example, try to understand the legal dynamics underlying it, and then I'll offer some thoughts. Gesundheit. So how important is this issue? That's a question I guess you all can decide. What we certainly can agree on, I think, up front is that its pervasiveness cannot be denied. Information products are central to the economy, and so if we accept the centrality of information products to the economy, then we have to start saying, when you redesign your information product, does that now render you engaging in speech? If so, what are the implications for antitrust? A parallel track that we could go down, if this were a different type of presentation, would be to say, well, is every change to an information product arguably an innovation, quote unquote, which then would also give it a lot of buttress defense against an antitrust matter. Now, we've heard a bit about the Sorrell case, and so I'm not going to go through it again, other than to recognize that this discussion about beef jerky, it's a First Circuit's analysis, but you get to the real sense of what kind of tension's starting to arise. What, if anything else, is unique about information rather than other products? Of course, the Supreme Court reversed the First Circuit, and what's important is, notwithstanding some divide in the court, the justices all agreed that First Amendment applies in some way to the sale, disclosure, and use of information. Now, within this framework, I'm going to use Google and their rankings as my primary example. What do we have here? The information product is a search engine. We have a dominant firm, and we have the product redesigns, okay, changes to their search engine. And we know that these changes have been investigated, are currently being investigated, particularly abroad, and they've also been challenged by some parties as anti-competitive. And the defense launched, among the defenses raised, is suggested by the white paper by Volokh and Falk that says the First Amendment protects search engine results against antitrust law. At the risk of oversimplifying, they're basically trying to analogize their undertaking of the search engine to being a newspaper editor. And I get to decide what news goes in my newspaper or not, and what goes above or below the fold. And therefore, the First Amendment immunizes, so the argument would go, Google from antitrust scrutiny. Now, AC Nielsen, their TV ratings, not going to discuss it at all, other than to flag this is not a Google issue. This is something that is infinitely broader and more profound, notwithstanding the attention that's focused on Google at the moment. Now, how have the courts actually handled this specific issue to date? And the answer is not so well. It's not that they've done it well or poorly so much as they really haven't done it much at all. Typically, these cases either settle or they are abandoned in terms of the investigation, or when they're decided, they're often decided on matters other than the First Amendment grounds. And so I do think, though, that there is reason for concern. Our speaker this morning, the FCC prosecutor Travis LeBlanc, identified that incommensurate values are implicated, and in those instances, it's really hard for antitrust. And I couldn't agree with him more. And the reason is that antitrust prides itself on being able to make trade-off. That's what we think we can do well. We try to identify and balance pro and anti-competitive effects. But it's a lot easier to do this kind of balancing when you're comparing apples to apples. So when you're comparing sort of narrow conceptions of consumer welfare and efficiency, and everything is similar, how are you supposed to trade off or balance speech and consumer welfare? The same can be said about static and dynamic efficiency. Dynamic efficiency, of course, being the issue of innovation. So, at the risk of oversimplifying, to date, what antitrust has done is they have basically approached the intersection of the First Amendment and antitrust by saying we have a binary approach. If it's political speech, you get immunization. If it's not political speech, it's non-speech. It's sort of nothing, and there's no solicitude. And that means that the antitrust laws are applied in full force. Okay? And the problem is that may work well when you have uncomplicated fact patterns, when you have clear instances of political speech. I'm trying to directly speak to the legislature. I'm lobbying them for something that's anti-competitive. But what you find, even in these sort of seminal cases, is you don't have to go too far before you start realizing that this binary approach doesn't work too well. And we see, in particular, in the NAACP Claiborne County and the Superior Court trial lawyers case, that those are instances in which the court's determination, for any number of reasons, to hew closely to this binary, political speech immunized or you get nothing, resulted in one instance the court sort of basically just not acknowledging facts on the books that were inconvenient, that would make their sort of designation of something as political speech harder based on the precedent. And in the Superior Court trial lawyers case, they also had to engage in a little sort of denigration of potential speech, because if they acknowledged it, they were afraid that, once I acknowledge speech, once I acknowledge speech, I have to immunize it, which means there's no antitrust. And for people that think that speech is of central importance, but actually the antitrust laws, competition has value as well, perhaps we need to think of a better way to navigate this issue. And I think that part of the problem, my tendency is to roam, so I'm going to keep walking away from the mic. I think part of the problem is that there's a tunnel vision. When you hear about antitrust First Amendment, there's always recourse to, not surprisingly, the antitrust First Amendment cases. And it means that we have some narrow, not necessarily great precedent that keeps getting reinforced. And what we need to do is need to be able to think more broadly. If we look at other speech cases, we see that, in fact, there's something other than immunization or nothing. And we've heard a lot already about the commercial speech and the intermediate scrutiny. And defamation is something where you have a conditional privilege, where you have this additional factor that has to be shown, actual malice, that is inserted as a recognition of the value and importance of the First Amendment. And so what we have to do is we have to think about what, if anything, can these alternatives tell us about how we should be navigating this intersection between antitrust and the First Amendment. And so, we're going down this speech pattern there's a complementary argument or parallel argument in terms of this binary nature that has to do with innovation, which I do think is important in the redesign context. But focusing on the the speech issue, I would, begin to address the issue by doing the following, okay? Antitrust, political speech is protected. If it's not political speech, then it's not protected, period. Okay. Let's keep the political speech part, of course. So if it is political speech, that's the upper bound, you're still going to get immunization. And then I would say, let's not call what we know is some speech, no speech. Or let's not just call it sort of just, I don't know, it's not political speech, therefore it's nothing. It's now going to be designated as nominal speech, and that gets no solicitude. Clear example of that would be price fixing. Price fixing, the speech is a mechanism to accomplish the illegal end. You get no solicitude. Antitrust applies fully. What's really important, though, is this sort of middle category that we need to create, and that's cognizable speech. And what I would say about cognizable speech is I wouldn't rely on defining it with reference to a specific information product. I would actually define what's cognizable speech largely with reference to the cause of action. And the cause of action, what I mean by that is if you're looking at something like a ranking or a rating, and someone says your redesign of the algorithm that leads to alleged anti-competitive effects, that's going to the substance of the information that's being conveyed. If you have a cause of action that's predicated on something more logistical, something that is not substantive, processing speed, interoperability, things like that, then you wouldn't be counted as cognizable speech. It would be treated as just a normal antitrust action, okay? And within that context, I think that we need to do some additional work, and this goes to the questions of different factors and that type of thing. And I think it's best to sort of just show sort of intuitively where I'm coming from. We see the political speech, which I do think needs to remain sacrosanct, and I think we can do a better job of protecting political speech if we don't have to sort of bastardize and gerrymander the border. If we want to have some protection of speech, we either have to give it all or nothing, and it leads to the sort of phenomenon that, I'm forgetting his name, but one of our colleagues in the First Amendment community talks about sort of in or out, and how you're basically having to gerrymander what gets into the category or not. And where I think the game has got to be played is cognizable speech. As you can see from how I've laid it out, essentially what I'd say is something like, if you have an antitrust action that is based on some claim about speech being deployed in a way that's anti-competitive, and it's about the content of the speech, then I would give some baseline solicitude that would get you out of we're just applying the antitrust straight away, right off the bat, with no solicitude. And I would, there are different factors that I think would give the speech a little more strength in terms of its ability to counteract the anti-competitive, the application of antitrust law. And the last point I'll make is that within this framework, there's actually an opportunity to think about whether or not the Anti-Competitive Act is harming what I would call secondary speech, which is the ability of other people to get their messages out, okay? And to the extent that it does, it would push you in the direction of having it be more nominal speech, meaning you don't get the protection. And my time is up, and what I sum up by saying is that the fact that I had to try to explain it in words, I have a big article that tries to explain my point. Then I had to put together like a picture that shows things directionally, because I don't know how much how to quantify and represent the value of the speech versus the value we attach to the anti-competitive harm. What I do know, though, is that it is that complexity that makes people anxious and makes them want to jump towards these very simple and oversimplistic solutions of it's all or nothing. And they want to avoid getting into that sort of messy reality. And in point of fact, for certain cases, the straight and narrow binary approach is great. But what we found is that it actually didn't work as well in the past as we thought it would, because some of these cases have some real problems. And information products, the way the antitrust cases are being brought, and the manner in which the First Amendment defenses are being raised, it's basically saying we need to transcend the binary approach, and my solution isn't fully formed or perfect, but I think it goes to the idea that we collectively need to try to enter into that messy middle ground. Thank you.